Judgment in the matter of Waller Edwards against One Savings Bank.
Lady Simler will explain the court's reasoning.
In order to explain the decision in this appeal, it's helpful to start with a short summary of the facts. The appellant, Ms. Waller Edwards, entered into a remortgage of a property she was living in with a Mr. Bishop, with whom she was in an intimate relationship. The remortgage was for £384,000 with the Respondent bank. The bank understood from Mr. Bishop that the remortgage would be to purchase another property for the couple to use as a buy-to-let and to pay off an existing mortgage debt. The bank required Mr. Bishop to use the loan to pay off his other existing debts, so that £25,000 would be used to pay off a loan for his car and £14,500 to pay off his credit card. The bank therefore understood that £39,500 of the loan would be used to discharge debts in Mr. Bishop's sole name. In fact, but unknown to the bank, the loan was used by Mr. Bishop for other purposes, with the result that when the relationship between the couple ended and Mr. Bishop disappeared, the appellant had no means of repaying the mortgage, and ultimately the bank commenced possession proceedings in November 2021. The appellant resisted the bank's possession claim at a contested trial in which Mr. Bishop played no part, arguing that she had acted under Mr. Bishop's undue influence when entering into the remortgage transaction with the bank. In doing so, she relied on principles established in a series of well-known cases in the House of Lords, including a case which we refer to in the judgment as Ettridge No. 2. She relied on those cases to argue that she was a surety, or a guarantor, for part of the loan made to pay off Mr. Bishop's sole debts, totalling £39,500, so that the bank was put on inquiry that her agreement to the transaction may have been obtained by undue influence, since the bank had failed to take steps to be satisfied that her agreement to act as surety had been obtained with full knowledge of the liability she was taking on. The appellant argued that the remortgage transaction should be set aside as between her and the bank. The judge in the county court found, as a matter of fact, that she had entered into the remortgage under the undue influence of Mr. Bishop. But the county court, the High Court, and the Court of Appeal all held that the bank was not put on inquiry that her agreement to the transaction may have been obtained by undue influence, because this was a joint borrowing transaction and not to be viewed as a surety transaction. On the appellant's appeal against that decision, the Supreme Court unanimously allows the appeal. I give the judgment with which the other justices agree. The judgment explains that the principle relied on by the appellant, as confirmed in the case of Ettridge No. 2, is that banks and other lenders are put on inquiry that one party's agreement to the transaction with the bank may have been obtained by undue influence whenever, on the face of a three-way non-commercial transaction, the wife or other vulnerable partner in the relationship offers to stand surety for her husband's debts, or vice versa. Joint borrowing is different, and in a joint borrowing case where on the face of the transaction the lending is advanced to husband and wife jointly, the bank is not ordinarily put on inquiry. The case law therefore establishes a clear dividing line between the two types of cases, surety transactions on the one hand and joint borrowing transactions on the other. A relevant surety transaction is a non-commercial transaction where the vulnerable party offers to guarantee the other party's debt, taking on a legal liability for nothing in return. When a lender is put on inquiry, it is required to follow the Ettridge Protocol. That is a series of steps, including obtaining legal advice, that are designed to reduce the risk of the vulnerable party being misled into providing a legal guarantee of their partner's debts for nothing in return. If a lender is put on inquiry and fails to follow the steps in the Ettridge Protocol, the vulnerable party is entitled to set aside the transaction as against that lender. A relevant joint borrowing transaction, on the other hand, is a non-commercial transaction for which, on the face of it, both are jointly liable. For example, husband and wife taking out a joint loan to purchase a car or a second home. In such circumstances, the bank is not ordinarily put on inquiry, and since the bank is not put on inquiry, it is not required to follow the Ettridge Protocol, and there can be no question of the transaction being set aside on this basis. This appeal involves a non-commercial loan which was, on the face of it, partly joint borrowing and partly to discharge Mr Bishop's sole debt, and to that latter extent to the financial disadvantage of the appellant. We call this a hybrid transaction. The question for the Supreme Court to decide was what is the correct legal test for determining when a lender is put on inquiry to follow the Ettridge Protocol in a non-commercial hybrid transaction of this kind. The Court of Appeal concluded that a fact and degree test should be applied. In other words, it said the court must look at the non-commercial hybrid transaction as a whole and decide as a matter of fact and degree whether the loan was being made for the purposes of the borrower with the debts as distinct from their joint purposes. It held that in this case the loan was looked at as a whole and from the point of view of what the bank knew, joint borrowing made for their joint purposes. Therefore, the bank was not put on inquiry. The appellant argues that a fact and degree test is wrong, and in allowing the appeal, the Supreme Court agrees with her. We explain our reasons for that conclusion at paragraphs 46 onwards. We start by explaining that the rationale for courts treating surety transactions differently from joint borrowing transactions is the recognition that a surety transaction is more likely than other transactions to be tainted by undue influence, because on the face of it, the vulnerable party is incurring a financial risk for no apparent personal gain in return. On the other hand, the risk in a joint borrowing transaction is much lower, because on the face of it, both parties are personally liable for the debt and both stand to benefit. Because the risk of undue influence is sufficiently high in a surety transaction, it is regarded as proportionate to place a requirement on banks faced with such a transaction to follow the Ettridge Protocol in order to avoid being fixed with notice of wrongdoing. On the other hand, in a joint borrowing transaction, the risk of undue influence is sufficiently low to conclude that it would be unduly burdensome to borrowers to require banks to take any additional steps. That reflects a binary approach. Either a creditor is on notice of the risk of undue influence and must follow the Ettridge Protocol, or the creditor is not on notice and no steps are required. There is no spectrum of lesser or greater steps to be taken by a creditor put on inquiry that varies depending on a spectrum of risk. Nor is there any scope for a nuanced or fact-sensitive assessment of the risk posed by the transaction. Again, either there is, on the face of the non-commercial transaction, a surety element giving rise to a heightened risk of undue influence, or there is not. As a matter of fact and logic, the level of risk of undue influence presented by a surety transaction is the same, whether it is accompanied by joint borrowing or not. The hybrid element does not reduce that risk. These considerations are primarily what led the Supreme Court to the conclusion that the fact and degree test adopted by the Court of Appeal is wrong. The correct test remains a binary or a bright line test, even in a hybrid case. In other words, a creditor is put on inquiry in any non-commercial hybrid transaction where on the face of the transaction there is a more than trivial element of borrowing, which is to discharge the debts of one of the borrowers only, and so might not be to the financial advantage of the other. The transaction must always be viewed from the bank's perspective, but if viewed in this way, there is a more than trivial element of borrowing, which is to discharge the debts of one of the borrowers only. It should then be regarded as a surety transaction, and the creditor is then placed on inquiry of the possibility of undue influence, and the steps set out in the Ettridge Protocol must then be taken. That bright line test is clear and promotes certainty. It is easy to apply in all non-commercial hybrid transactions. The onus of inquiry can be discharged simply and inexpensively in accordance with the Ettridge Protocol. Applying the correct test to this case, the appellant took on a legal liability for the loan to discharge Mr Bishop's debts of £39,500. She received nothing in return. The amount involved was not trivial, and for all those reasons, the appeal is unanimously allowed.
The court will now adjourn.